Hello, everyone. Welcome to the final talk in the 2025 Hot Topics in Environmental Law Summer Lecture Series. I'm Christophe Courchain, Faculty Director of the Environmental Law Center and Associate Dean for Environmental and Experiential Programs here at Vermont Law and Graduate School. Each one of our talks this summer is worth one Vermont CLE credit, so please keep track of which talks you attended for your records. We'll have time for Q&A after today's presentation. For those of you watching on VLGS YouTube, please feel free to enter your questions in the chat space on the right-hand side of the page at any time, and we'll get through as many as we can. Today we're very, very pleased to welcome back Dana Drugmand. Dana is an environmental journalist covering topics such as climate accountability, climate change lawsuits, greenwashing and false climate solutions, plastics and petrochemicals, as well as environmental law and justice generally. Dana has over 5 years of experience in legal reporting covering climate law and litigation, and she runs a startup news site focused specifically on climate litigation called Climate in the Courts. Her writing has appeared in The New Lead, Sierra, DSmog, Yes Magazine, New Internationalist, Common Dreams, Truth Out, and Earth Island Journal, among other outlets. In 2017, Dana completed a master's degree in environmental law and policy with a certificate in climate law right here at Vermont Law and Graduate School. Dana returns to us this summer as one of our environmental media fellows who were selected from a highly competitive pool of journalist candidates. Today, for our hot topic, she will present Climate in the Courtroom inside the historic Held versus Montana youth climate trial. Please join me in welcoming Dana Drugmand.
Thank you. Thank you so much. Yeah, really great to be back here in Vermont, and I've really enjoyed my time here these last 2 weeks. It's a little bit of a homecoming for me. So yeah, I want to start off here by setting the scene and taking you inside, as the title suggests, inside the courtroom for this really historic climate change trial. Really the first of its kind here in the United States. As one of just a handful of reporters who was on the ground covering this trial in person in Montana, I was fortunate to have had a front row seat to history in the making. And I'll talk more about that in a little bit. So my goal here is to give you a taste of what it was like to witness this, because it really was environmental law in action. And also to let you hear directly some of the voices of the youth plaintiffs. So I'll talk about what happened in this trial and what it means, and then I'll zoom out a bit and discuss a little bit of the broader landscape of climate litigation, which is an area that I've been following closely and reporting on for some years now. I will also highlight a couple of other key cases that I think are important and could potentially have some impact. So I'm sure many of you tuning in are familiar with this case called Held v. Montana. It was filed in 2020 by lawyers with an organization called Our Children's Trust, which spearheads youth climate litigation against governments at the state and federal levels. So this case involved 16 youth activists from across Montana asserting that state energy policies that boost fossil fuels were contributing to dangerous climate change and therefore were violating their rights under the Montana Constitution. And what's interesting about Montana's Constitution specifically is that it includes the right to a clean and healthful environment. It's one of only 3 states that establishes this as a fundamental right in the Declaration or the Bill of Rights section, giving it the highest constitutional positioning. So that constitutional argument was the basis for the claim here. And by the time the case went to trial, there was one state law in particular that was being challenged. It was an update to the Montana Environmental Policy Act, which is the state equivalent of NEPA or the National Environmental Policy Act. And this update or amendment to the Montana Environmental Policy Act specifically prohibited state regulators from considering greenhouse gas emissions or climate change impacts of projects like fossil fuel development when doing environmental impact assessments. So it effectively shielded fossil fuel projects from scrutiny over their climate impact. And the court referred to this policy as the NEPA limitation because it restricts or limits what the state can consider under the Montana Environmental Policy Act, or NEPA. So that's the case in a nutshell. You have 16 kids taking on their state government, in this case, Montana, whose political branches are controlled by Republicans, taking them to court over a blatantly anti-climate policy, which the kids say violates their constitutional rights. So to set the scene here, it's June of 2023, and the trial, which is scheduled for 2 weeks, is about to begin. It's in a small courtroom in Helena, the state capital, and there's a palpable sense of nervousness and excitement. And this photo here shows the scene inside the courtroom right before the trial began. And as you can see on the left here, you have the government defendants, and on the right, the lawyers for the youth plaintiffs just discussing amongst themselves. And then here you have some of the plaintiffs and one of their lawyers seated in the front row. In the foreground, here are the two youngest plaintiffs, and they're seated next to Ricky Held here, who is the named plaintiff. And you can't really see it from this picture, but I am seated on the side of the courtroom over in the jury section, which is where they had the media sit, because there was no jury in this case, just a judge, Judge Kathy Seeley, presiding over the trial. So after opening statements from each side, the lawyers for the plaintiffs called their first witness, May Nan Ellingson, who was the youngest delegate to the 1972 Montana Constitutional Convention, which was when the state drafted an updated version of its constitution. And that included the right to a clean and healthful environment. So Ellingson was able to provide the historical context on what the drafters intended in including this right. And she was able to tell the court that it was meant to be as strong as possible. And as you can see here, the right was prescribed into two different parts of the Constitution, in Article 2 and Article 9. And language referencing the state's natural beauty and environment was also woven into the preamble. So after Ellingson, lead plaintiff Ricky Held was called to the stand to testify, and she told her personal story about how she has been impacted by climate change. Now, Ricky grew up on a ranch in Montana, and she has dealt with wildfire smoke, floods and droughts, and extreme heat. And there was a moment when she was telling her story and she got choked up, describing what it was like working outside on the ranch when it's smoky and temperatures are above 100 degrees. Her testimony was followed by another expert witness, Stephen Running, who was a climate scientist in Montana. And then the court heard from two more plaintiffs, Grace and Eva. And this is a picture here of Eva getting sworn in. And I'm actually going to circle back to her because she is now fronting a new case, which I will talk about. And that was just the first day. testimony on the plaintiff's side continued for the whole first week, and the flow was intentionally structured so that you had expert testimony interspersed with the stories of these young people. And that worked really well, I thought. As for the experts, they included climate and environmental scientists, doctors and medical professionals, and experts in climate policy and energy. And this shows just a few of them here. One of the experts, Ann Hedges, is actually a Vermont law graduate. And this picture shows her testifying and also a slide just outlining the main conclusions from her testimony. And she is an environmental policy expert in Montana, and she told the court that the state has never once denied a permit for a fossil fuel project. As for the youth plaintiffs, their testimonies were all really compelling. And there's one moment that really stood out to me. And I want to play just a short video clip here for you. So this came at the end of that first week. The last plaintiff to testify was Lander, and he delivers a really powerful condemnation of his state government, which is supposed to be protecting him. So I'm going to play this clip here, and this is just under 3 minutes.
As proud as it makes you feel, Lander, how does the fact that Montana state law requires Montana's agencies to ignore greenhouse gas emissions and climate change when conducting environmental reviews for fossil fuel permits, how does that make you feel?
Again, I don't know how you can sit in this courtroom at all and listen to these experts and not just the evidence, but the pleas that they have. Dr. Stanford and Dr. Running remarked on how they've never seen such language in reports such as these for the direness of the situation. And the state has one job, to look out for us, for me, and I can't really believe that this much can be put on display in a court of law, and yet still we can be so vigorously shut down by a government that doesn't respect our right to the legal process. We have been almost shut down from getting into court 8 times, whether that be through the court itself or through the Supreme Court trying to get our case dismissed. The state government did not even want us to have our day in court, let alone for the facts to be presented about how detrimental this is to everyone in the state. It's just another clear example of the government putting profits before the people that it is supposed to serve. And it's so frustrating and disappointing to see it on such a wide and systematic level as we've seen in the last few days. So I can't speak to the exact emotions of Governor Gianforte or Attorney General Knudsen towards our case, but the statements towards our case and everything that we've worked so hard for these last 3 weeks have been nothing short of disrespectful, vicious, and wrong, and completely disregarding what this state and its constitution were initially ratified for. So I'm very disappointed, but I'm still optimistic that this may be some catalyst for change.
Yeah, really powerful stuff there. So that was inside the courtroom, but I also want to give you just a little flavor of what it was like outside. So each day, supporters of the youth would gather outside the courthouse and cheer on the plaintiffs and their attorneys as they made their way towards the entrance of the court. And this is a short clip here. Play now, it's just 30 seconds. All right. And then on the last day of trial, once it was all over, there was a gathering at a nearby park for community members and supporters of the youth. And some of the plaintiffs spoke. So I want to play just one more short video clip here because it really puts you there in this park and takes you behind the scenes in a sense, since most folks didn't get to see these speeches unless you were there. So this is one of the plaintiffs here, Kian, who's speaking.
I want to speak to you. So I sort of wrote a list of thank yous. First of all, I'd like to thank my fellow plaintiffs. Recently I've been reflecting on where my people are, and during this case I found them. I think it's really important to find a special group of people that you can surround yourself with and really connect and embrace, and they feel like family, even if they aren't by blood, and we are family. Secondly, I'd like to thank the attorneys. Wow, that was actually incredible. I learned so much, and I'll be honest, my entire plan was to travel the world, be a climate activist, play soccer, and I'm now reconsidering, I'm considering being an attorney because of the work they've done. It's really incredible. Third, I don't think anyone's really thanked them. Well, they have been thanked, but all the work behind the scenes, the paralegals, the assistants, thank you so much. It is like, we would not be here without you, so thank you so much. I would also like to thank the parents. I know I would not be here without my parents, my mom and my dad, and all the parents for all the plaintiffs. Thank you so much for being here. Thank you so much for supporting us. Thank you for giving us the opportunity to share our stories. And then lastly, my last thank you is to all of you, all of the supporters, everyone who's tuned in to our trial, everyone who's here right now, all the organizations. Thank you so much. We would not be here without you. We need you. We need your support, and this is just the beginning. I don't think I've ever seen so much potential for change in one place in my life. We are writing history right now, and we are going to continue to write history. We aren't backing down. We're going to continue to fight for our future and for every future, for every Montanan, for future generations to come.
Yeah, amazing. He said he thinks he might want to be an attorney, so maybe he'll consider applying to Vermont law. Who knows? But what he said at the end there about making history really captures what this trial was all about. It was history in the making, and being there to see it all unfold was truly something very special. So I think most of you know what happened next, but actually to just back up a little bit, so the state did get its turn to put on its defense, and it was a lot of the whole second week, but really the state didn't have much of a defense. so it only took one day. And it put just 3 witnesses on the stand, 2 officials with the state's Department of Environmental Quality, and then 1 free market economist who actually got called out during his cross-examination for errors that he made in his expert report. One of the state's star witnesses, Judith Curry, who's a climatologist, and she's one of the very small cadre in the small group of climate deniers or contrarians. She was scheduled to testify, and then at the last minute, the state decided not to put her on the stand because the state apparently decided that it wasn't going to try to contest the climate science. And Judith Curry is now one of the authors on this new report that was just submitted this week to try to justify the US EPA's rolling back of the endangerment findings. So that's kind of an interesting point there. But anyways, if you're the judge and you're weighing the substantive testimony and evidence put forward, the plaintiffs had 24 witnesses and the defendants had 3. So it's not a close call, really. It's easy to see that it weighed in favor of the plaintiffs. So on August 14th, 2023, Judge Seeley issued her decision, and it was a decisive victory for the youth plaintiffs. The ruling struck down the state law prohibiting consideration of greenhouse gas emissions during environmental reviews, the so-called MEPA limitation, as well as a related state law having to do with legal challenges brought under the Montana Environmental Policy Act on climate change grounds, basically saying that those legal challenges shall not delay or inhibit fossil fuel permitting or authorizations. So those 2 state laws, both bills that were passed by the Republicans in the legislature in the session right before the trial, those laws were found to be unconstitutional in Montana. The ruling also affirmed the youth plaintiffs' right to a clean and healthful environment under the Montana Constitution, and it said that this right includes the climate system. The court found, based on the expert testimony, that climate change is already degrading Montana's environment and harming the youth plaintiffs, and that every ton of fossil fuel emissions authorized by the state further contributes to this degradation and harm. And this is a quote here from the court's decision, said, quote, "The degradation to Montana's environment and the resulting harm to plaintiffs will worsen if the state continues ignoring greenhouse gas emissions and climate change." So this is widely considered a groundbreaking or landmark ruling. One climate law expert, Michael Gerard from the Sabin Center on Climate Change Law, he called it the strongest decision on climate change ever issued by any court. And these here are screenshots of 2 of the articles that I wrote about the decision. And then what happened? The state, of course, appealed, and it went directly up to the Montana Supreme Court. And that court handed down its decision in December of last year, 2024, ultimately upholding the trial court's judgment and solidifying the youth plaintiffs' victory over their state government. So that's an overview of the held case and the historic climate trial. To have such a breakthrough victory happen here in the United States is really remarkable. This was essentially the first time in our nation's history that a court has held government officials accountable on constitutional grounds for policies contributing to the climate crisis. I've been following this strand of youth climate litigation led by Our Children's Trust for the last 10 years now. And for the most part, courts have not been very receptive to these types of constitutional climate arguments. But we may be starting to see a shift in that pattern, at least in states like Montana that have strong environmental rights provisions in their constitutions. Overall, though, climate litigation, especially the more strategic kinds of cases that are really centered around accountability or compelling stronger climate action, this is a topic that I found to be quite fascinating, and it's a rapidly evolving and growing area of environmental law. This chart here shows the growth of climate cases over the years, and this is from the most recent Global Trends in Climate Change Litigation report from the Grantham Research Institute in the UK. To date, there's been almost 3,000 climate lawsuits filed around the world, and the vast majority of them are here in the US. And to share a quote from this report, it said, quote, "As climate change intensifies and its impacts become increasingly visible, litigation continues to evolve as a critical tool for shaping climate governance and accountability. Over the course of 2024 and into 2025, while the overall pace of new case filings has moderated, the field of climate litigation has expanded in complexity, reach, and influence." So, a critical tool for shaping climate governance and accountability. And even the IPCC, the Intergovernmental Panel on Climate Change, has recognized this. It's certainly a space that is worth paying attention to. And as a journalist with an academic background in environmental law, I think it's important to help communicate to the public about this litigation. You know, most journalists are not trained in law, so covering litigation and legal topics can be challenging. And that's why this fellowship is helpful to provide a little bit of that legal background. In my case, I was fortunate to have gone through the master's program here. And when I graduated 8 years ago in 2017, a lot of this climate litigation was just starting to take off, especially in the US in terms of the tort lawsuits filed by local governments against big oil. There are now more than 30 of these climate change deception lawsuits brought by states and municipalities against the fossil fuel industry here in the US. And out of those 30 plus cases, one that has gotten quite a bit of attention in the last few years, because it's now one of the furthest along procedurally, is a case brought by Honolulu, Hawaii. And this case has survived motions to dismiss in state court. And the Hawaii Supreme Court has upheld the lower court's rulings, so setting it on a path towards trial. And this on the left, here's a screenshot of an article I wrote about the Hawaii Supreme Court deciding to allow the case to proceed towards trial. The oil companies then tried to get the US Supreme Court to intervene. And the industry was hoping to shut down not just the Honolulu case, but all of the climate liability cases filed against it. But in January of this year, the US Supreme Court denied the cert petitions from the oil companies in the Honolulu case. So putting that case firmly on a path now towards trial. Nothing has been scheduled yet for a trial date. Pre-trial discovery, I think, is going to take a while. And right now, I believe the parties are litigating over a motion for summary judgment filed by the oil companies. But if anything is pretty clear at this point, is that the industry, the fossil fuel companies, are feeling pretty frightened by this litigation now, to the point where they have the Trump administration stepping in to play offense on their behalf. So in late April, early May, the Trump Department of Justice decided to sue 4 states, Hawaii, Michigan, New York, and Vermont, to try to challenge or block these states' climate liability laws or lawsuits. New York and Vermont enacted novel climate change superfund laws last year, which put big oil companies on the hook to help pay for climate change costs. And these climate superfund laws are now being challenged in court, as was expected. They're being challenged by the industry, by Republican attorneys general, and now by the Trump administration. But the lawsuits that Trump's Department of Justice filed against Hawaii and Michigan were a bit strange because they were brought preemptively before either of those 2 states had filed any case against the industry. Hawaii went ahead the next day and sued Big Oil, but Michigan still has not yet filed any lawsuit. And on the right, here's a screenshot of a news article I wrote about Hawaii suing Big Oil after the Trump administration tried to preemptively block it. So this battle between the Trump administration in these states that are now taking on Big Oil is definitely something to keep an eye on. And speaking of the Trump administration, there's a brand new youth climate lawsuit just filed 2 months ago against President Trump and his administration. The case is called Lighthizer v. Trump. Eva Lighthizer was one of the plaintiffs in the Montana case, is the lead plaintiff here. And actually, a lot of the plaintiffs that were part of that Montana case, 10 of them have come back together here to take on the Trump administration in this case. So overall, we have 22 youth plaintiffs, and some of them were plaintiffs in other youth climate cases, like the Juliana v. US, the landmark case against the US federal government, as well as cases against the states of Hawaii and Florida, in addition to Montana, of course. And the Hawaii case, and this is a different case from the Honolulu case, this case was brought by youth against the state of Hawaii. It was called Navahini versus Hawaii Department of Transportation. That case resulted in a historic settlement agreement last year, which puts the state of Hawaii on a path now towards full decarbonization of its transportation system. The settlement also recognized youth plaintiffs' right to a life-sustaining climate system under Hawaii's constitution. So 2 states now, Hawaii and Montana, have formally confirmed through their courts that there is a constitutional right to a stable climate. Now, the case here, Lighthizer v. Trump, argues violations of more traditional rights under the US Constitution, in particular, the rights to life and liberty. And unlike the previous federal case, Juliana, which tried to take on the whole US fossil fuel dominated energy system, this case focuses a bit more narrowly on 3 executive orders that President Trump signed, all of which are intended to, quote unquote, unleash fossil fuels and to undermine clean renewable energy and suppress climate science. 2 of these orders were signed by Trump on his first day back in office, including one declaring a so-called energy emergency And the third one, titled Reinvigorating the Beautiful Clean Coal Industry, that one was signed in April. And the Trump administration is already implementing these orders through a variety of actions, all of which are now being challenged here by these youth plaintiffs. The plaintiffs also make the argument that President Trump is acting beyond his lawful authority. I think the legal term there is ultra vires, since the actions undertaken by the Trump administration seemingly conflict with or undermine federal laws passed by Congress, like the Clean Air Act or the Global Change Research Act of 1990, which mandates the federal government produce the National Climate Assessment climate science reports. And those reports have now been just recently scrubbed from the internet. So anyways, that's the newest youth climate case here, launched by Our Children's Trust. So it's really a right to life case. And there are a lot of familiar faces with these youth plaintiffs. So it will be really interesting to see how this case unfolds. The lawyers for the youth are seeking, as a first step, a preliminary injunction, which would immediately halt implementation of Trump's fossil fuel orders. And the request for a preliminary injunction is backed by expert declarations, including from some of the same experts who testified in the Montana trial. So we're seeing how the lawyers are building off of that successful case going forward here with new litigation. The latest procedural update here is that there will be 2 days of trial, or 2 days of hearings, not a full trial, kind of a mini trial. 2 days of hearings coming up in September on the 16th and 17th, as the court, and this is a federal court in Montana, by the way, the court will consider both the preliminary injunction request as well as the government defendants' motions to dismiss, which will be filed next week, I believe. And to wrap up here, I want to give the last word to Eva Lighthizer. So I'm going to play this short audio clip from an interview that I did with her recently, because I think this brings it full circle, all the way from the held Montana trial to the new case here that she's fronting. So I'll play this really short clip. Why did you want to get involved again as a plaintiff, and the lead plaintiff in this case, taking on the US government and President Trump?
You know, in some ways it kind of felt like the logical next step. Being a part of HELD was so victorious in so many ways, because we really had our voices heard. And now we're facing an administration that is doing so much to undermine, you know, all the work that's been done in the past on climate change. And it feels, you know, absolutely crucial that I take action now. And yeah, we just don't know what we're going into. So doing as much as we can is really important to me.
Yeah. And that is all I have. Thank you so much, and happy to take some questions.
Terrific, Dana. Thank you so much for surveying that landscape for us. And we do have some time for some Q&A on this topic with Dana. And if you have a question, as I mentioned at the beginning, please put it into the right-hand side of the chat space on the VLGS YouTube, and we'll try to get through as many comments as we can. So I'll just start it off, Dana, with your reflections on covering this beat of climate litigation, and if you could speak to maybe some of the challenges that you've had, as well as some of the things that you really like about it.
Yeah, it's definitely an exciting beat to cover. Um, Challenges, uh, it can be sometimes difficult to keep up with everything. There's so much happening, but also, I'm not a lawyer myself, so trying to understand everything that's happening. It is, very complex, but having a legal background, like I said, definitely helps with that. But yeah, there's just so much happening, not only in the US, but outside of the US. I also cover the global um, picture too. So yeah, there's a lot happening there.
So it's challenging to keep track of all that's happening, especially when you consider the difference in that chart you showed from the time you started doing this work 10 years ago to now. It's just humanly impossible to cover the ins and outs of hundreds and hundreds of cases around the world. What are the tools that you use as a journalist to A, pick the things to focus on, and B, keep on top of things? And I think it would be interesting to our audience to, yeah, get a little bit of a look behind the curtain of that process for you, as someone who, like our students here at VLGS and like others who may be watching, are trying to follow these developments, despite the fact that, you'll read a story about a case, but there won't be a link, to the actual filings in the case or the docket number. That can be challenging for our students. How do you approach this from a almost a technical matter of trying to keep on top of all this stuff?
Yeah. So I focus mostly on like the strategic litigation, like I mentioned, and the way I think about it or conceptualize it, it helps me to think about it in this way is you have kind of two buckets of cases. You have cases against governments and cases against corporations. And there are databases out there that do track this. The most comprehensive and widely used, I think, is the Sabin Center's climate change database. But litigation can go both ways, right? It's not just activists or government entities or communities suing industry or governments getting sued. It can also be the industry bringing lawsuits, or, kind of the backlash litigation. And that is something I think we may be seeing more of. It is starting to pick up. Like I mentioned in my talk, the Trump administration is now suing 4 states here. But yeah, there are all kinds of climate cases. There are some of the more procedural types of or cases brought that are challenging, like discrete permitting decisions or regulations or those types of cases I don't tend to follow quite as closely. But as far as where to get this information, I would say, yeah, the Sabin Center's database, or in the US, PACER is the system for finding federal court dockets. So
That's very helpful, Dina. And I think the Saving Center has an incredible database, and certainly Pacer or its counterpart, Recap, which is a free version that has some of the filings, not all of the filings, are certainly out there for people to dig into. And obviously requires a little bit of legal training, which you've had while you were here to, sort of what's the difference between a federal and state court and how are they playing out, how are these cases playing out differently? And so thinking about your task of conveying complex legal information to a generalist audience, how do you think about that project, that work, given how it can get hyper technical very fast?
Yeah, yeah, it can for sure. And, in terms of the tort cases against big oil that like I mentioned, um, a lot of what I had reported on, what's happened so far in these cases has been really technical. It's been these procedural developments, where the industry has tried to get these cases moved to federal court. They were pretty much all filed in state court. So you had this battle that has gone on for a couple of years in some of these cases. So, that may not be super interesting to the general public, but it's what has happened in these cases. So, it still is something that you have to cover if you're covering this beat. And yeah, I think it can be challenging to try to communicate this, and a lot of the public isn't going to be that interested in kind of the legal technicalities, or when there's like a big decision that comes out. But yeah, I think we will be seeing a lot more of these lawsuits being filed in the US and abroad. So it's definitely not something that's going away.
So another sort of question brought up by your talk and by, I think, our engagement with the Art Children's Trust advocacy on children's climate litigation more broadly. And in that respect, I'll highlight that co-executive director of Our Children's Trust, Julia Olson, received an honorary degree here at VLGS in May and gave a wonderful lecture on the work of Our Children's Trust. And I encourage those folks who are watching today and got a taste of the sort of discussion of Held and these other follow-on cases might find that lecture very, very interesting, hearing from Julia about the evolution of those cases and sort of the theory behind them. The thing that I was hoping you might sort of reflect on is these cases, and this is true of other climate cases as well, are about capturing the public's attention. They are part of an advocacy strategy. This goes back a long way in our country in terms of public interest impact litigation. It's been part of that picture. It's part of something I teach in the environmental advocacy clinic here to our law students. How do you reflect on covering that as a journalist, where one of the goals of those cases is to attract your attention and get stories written about them? How do you think of your role, vis-a-vis that advocacy approach that public interest litigants often are employing?
Yeah, that's a good question. I think, I'm someone that is following this, and I'm definitely very keen to cover this. But I think a lot of the news media tends not to pay quite as close attention to the litigation, unless there are some like major big developments. Like if a new case gets filed, that will get media attention. If there's a particularly significant ruling in the case, even if it's a procedural ruling, that will tend to get coverage too. The held case was, it was the first trial of its kind, like I said, and it did get quite a bit of media attention in the US and internationally. There weren't that many reporters that were there on the ground covering it. There was a small handful of us. I think some of the larger outlets had reporters cover just like the first day of the trial and like maybe the end of it. But yeah, that definitely is a key objective of this litigation, right? Is to not just win in court, but to also try to win in the court of public opinion, right? That's how you make this change.
So, as you're looking ahead, and thinking about kind of climate action overall as a topic to cover, how do you confront an issue like the one you alluded to, which is that we have a proposal that was released this week to repeal the endangerment finding from the Trump administration, and attached to that effort earlier in earlier this year, a scientific review was completed at a federal agency that is in broad tension with decades of climate science, as well as the National Climate Assessment, in terms of the risks and impacts and appropriate mitigation measures for climate change. Yeah, how do you think of the backlash that we see playing out, and what the role of journalism is in the face of that effort, given the science that you outlined and that really was presented in the held case, for example, and will continue to be part, that was affirmed and resounding fashion by the ICJ, the International Court of Justice, last week. How do you approach that task as a journalist, thinking about these two sides that perhaps aren't exactly two sides?
Yeah. I mean, I think we have to just try to report on, the facts and, convey the science. And the science is very clear, right? What the Trump administration is doing here is just kind of absurd. Like, it should not hold up in court. You would think, the endangerment finding repeal will definitely be challenged. But the climate science is just so solid at this point. And, the trial showed that, like the state of Montana didn't even try to contest the climate science. So I think, as journalists, we have to try not to get swept up so much in, yes, there are like these two sides, but the public needs to know that, there really is the anti-climate science side doesn't have much credibility to it, right? So I think just trying to convey, where the weight of the evidence stands at this point. And right now the science is clear, and now the law is also very clear. And the International Court of Justice really solidified that with its advisory opinion last week. So,
well, a really important, interesting topic, and a great exploration of that, history making climate trial out in Montana and subsequent developments. So Dana, we very much appreciate you sharing with us today, and I think we'll wrap up here. And I do, in addition to thanking you, Dana, for participation and being one of our fellows this summer, I want to sort of thank all of you who've joined us this summer to watch our Hot Topics Summer Lecture Series. The good news is that you can continue to watch these lectures, whereas they will be archived on the VLGS YouTube channel. So if you missed one, or you want to go back and revisit something on a topic that is of interest to you, please do so, and please use that as a resource. They live on our website, and we also have an archive going back a number of years of these lectures. And I think you probably can, over the course of that archive, you can see the sweep of some of these issues as they've evolved, as we often have talks on topics that recur, and so you can see how the conversations evolved. So very interesting opportunity there. As we close out the summer of our Hot Topics lecture series, I would really like to extend a couple thanks. One to Brian Basha for technically running this program so smoothly, bringing our lectures to YouTube live, week in, week out throughout the summer. I think 15 times this summer or thereabouts. And also, you know, to Courtney Collins, our assistant director of the Environmental Law Center, who painstakingly and carefully organizes the speakers and the topics for the lecture series over the course of many months. And we're really grateful to Courtney for her hard work. And certainly thank you to all of you viewers who joined us, whether live or on the recordings. We're doing it for you, and we appreciate your participation and interest. And so one final thank you for joining us, and have a wonderful conclusion to your summer. Thanks, everyone.